Certainly, I want to break there is going to be discussion. At least share. Yeah. Some of it is
You're right.
I can give you my
Very much so. Considering Jack hasn't cleaned his glasses in 4 months.
I got the smell of the water.
Oh, peeps.
I didn't know that you read it. I just wanted to make sure. All right, so we have that on. It's the only thing that you have to
Well, this is, it's good reference.
What did I just pull up? I literally just pulled it up, just to have it on hand, because I need it. I didn't really, I knew you read it, I didn't think you. I want you to know
Demonstrated.
I still think you. You good? Okay, welcome everybody to this regular planning board meeting, March 23rd, 2022. Madam Secretary, can you please call the roll?
Mr. Bernardo?
Present.
Mr. Katsif?
Here.
Mr. Lilly?
Here.
Mr. Hendeman?
Here.
Mr. Moody?
Here.
Mr. Knoll?
Here.
Councilman McAvoy?
Present.
Mayor Roman?
Here.
Vice Chairman Breshke?
Present.
Chairperson Pearson?
Here.
And Mr. Massera?
Here.
We are also being joined tonight by 2 engineers from Boswell, Frank, whose name, I'm sorry, I still don't have it down. Dobashevsky and Mr. Alvaro Gonzalez. Can everybody please rise for the Pledge of Allegiance?
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The notice requirements of the Open Public Meetings Act have been satisfied with respect to this meeting of the Township of Verona Planning Board, which is being held in the ballroom of the Verona Community Center located at 880 Bloomfield Avenue, in Verona. Specifically, the time and the date were included in the public meeting notice, and this information along with the meeting agenda was posted to the municipal building and sent to the official newspapers of the township at least 48 hours preceding the start time of this meeting. The agenda and public handouts for this meeting can be viewed online at www.veronanj.org/planning board. A public comment period will be held in the at the appropriate time. We do not have any meeting minutes this evening, although I am told that miraculously they're ready. So she may send them out early next week just to give everybody ample time, and then we'll obviously deal with those at our regular April 27th meeting, along with tonight's. At this time, if anybody from the public has any, does anybody from the board have any new business or anything like that that they want to bring up? Anyone? Okay. If anybody from the public wants to speak on anything that is not on this evening's agenda, please come to the mic, state your name and address for the record. And seeing none, we will close public participation and hand the meeting back over to Mr. Inglesino to continue application 2022-04, preliminary and final site plan for 1 Sunset Avenue, Block 303, Lot 1.
Thank you, Madam Chair, members of the board and the public. John Inglesino on behalf of the applicant, 1 Sunset Avenue LLC. This is a continuation of the hearing, last adjourned on March 16th. Applicant has applied for major site plan approval for a 200-unit multifamily inclusionary development comprised of 185 market rate units and 15 affordable units. This application is made pursuant to a Mount Laurel settlement, which settlement has been made part of the record. We have 2 witnesses this evening, Madam Chair. The first, we're bringing back Sean Savage. Mr. Savage will address the contents or comments raised by Boswell, Mr. Gonzalez, and a letter dated March 21 of 2023. And he will then entertain questions. As you may recall, Mr. Savage testified extensively at the last meeting and answered questions from the board. I think we left off, he had not yet answered questions from the public. Obviously, if the board has further questions of Mr. Savage, he's here to address them this evening. After Mr. Savage, we'll have Mr. Raker. You may recall that Mr. Raker is the architect. He testified as to revisions that were going to be made in the architectural plans. He's made those revisions, submitted the plans, and he's here tonight to provide testimony as to those changes and answer any questions that the board has. So at this time, Madam Chair, I'd like to call Mr. Savage.
Yeah, just one, I just want to, at least for the record, state that the memo that you sent came in at like 5 to 6. I did immediately distribute it, but I doubt anybody from this board, including the 2 engineers, had time to review your comments that were sent back, or the comments that were sent back on behalf of Mr.
Mr. Savage is going to testify as to those things, so I wanted you to have it, but it's not essentially. Mr. Savage is going to provide testimony on
All
the
right, and I'm just letting you know it's not been posted to the website or any of that.
That's okay.
Not many people have had 2 minutes to look at it, so just for the record, thank you.
Okay, Mr. Savage, you understand you're still under oath, correct?
Correct.
Have your credentials that you've testified to previously before the board in this matter changed in any manner whatsoever since your last testimony?
No, they have not.
So your license is still good?
Correct.
Okay, Mr. Savage, you've received a copy of the Boswell letter dated March 21, 2023, correct?
Correct.
Let's go through the letter so that you can testify in regards to the contents that were posed by it. Point 1 indicates that during the hearing on March 16th, you stated that Boswell had agreed that the capacity analysis of the existing stormwater was not necessary. This statement does not represent Boswell's technical commitment on the matter, but Brightview Engineering's. I'm going to handle that one because that is just factually incorrect. That is very incorrect. The February 16 letter from Boswell, I want the record to be clear on this, on page 2213, and I'm going to read it into the record. And this is quoting from the Brightview letter. Well, let me first of all reference the Brightview letter. The Brightview letter, Brightview issued a letter on August 15 of 2022. On page 4 of that letter, which is number 13, Brightview says, applicant must complete a capacity analysis for any township storm sewer structures that this project will discharge to. The analysis will be needed to confirm that any new connections can be accommodated by the existing system. That is a comment that was not made by Boswell. It was made by Brightview. I just read from the Brightview letter. We received the Boswell letter of February 16. And on page 9 of 22, number 13, in the non-bold type, they repeat the same sentence that I just read to you from the Brightview letter. The way they structured the letter was to repeat the Brightview letter, and then Boswell answered the letter from Boswell in bold, okay? So I would read the text that is unbolded in the Boswell letter, but it is exactly the same language that was in the Brightview letter. Now let me read to you the Boswell portion, which is in bold. Boswell says, it is noted that the proposed development will result in a reduction in the runoff rate directed towards the existing drainage inlet located within Sunset Avenue. Therefore, this is Boswell, the reduction in runoff rate will not have a negative impact on the downstream drainage system, and no downstream capacity analysis is required. That doesn't come from Brightview. That comes from Boswell. Nevertheless, Boswell then, in its March 21 letter, says that the statement that I just read to you from Boswell does not represent Boswell's technical opinion on the matter, but Brightview Engineering's. That is ridiculous. That is just patently ridiculous. Boswell gave its opinion. It's in bold. It is what it is. Now, we just have to...
If I could cut you off, and I will cut you off. I'm reading that it says, it is noted that the proposed development, et cetera, et cetera. Let's get to the bottom line. Is there a reduction in runoff rate or is there not?
I'm going to have Mr. Savage testify to that.
Okay.
Because
if there's not a reduction in runoff rate, because what I read that it is noted, I don't read that Boswell confirmed or did not confirm. Okay? It is noted by Brightview that it will result in a reduction. Okay? Even if they said it is, therefore, there is a reduction, and our engineers have now said there is not a reduction, even if they say we erred, which they certainly did not, then we're entitled to whatever we need in order to be satisfied.
No, I understand it.
But most importantly, our engineers, Boswell did not agree or disagree. They simply say it is noted that the proposed development. Now, perhaps there should have been then their conclusion, but there's not.
Well, there is.
But there is no
read the last sentence. It says, therefore, the reduction in the runoff rate will not have a negative impact on the downstream drainage system, and no downstream capacity analysis is required. That's pretty definitive.
If the proposed development results in a reduction in the runoff rate, that's the only issue.
Well,
this is all semantics. Okay. If the proposed runoff rate results, if there's a reduction, then I think everybody's satisfied.
Yeah,
if there's not a reduction, then it's not.
Right. There was testimony from Mr. Savage on this exact issue
Well, let's hear
a
it.
week ago.
Right.
And that this letter came after that testimony.
Okay.
So we will have the testimony from Mr. Savage again. And I apologize to the board and to the public that we're going to do this twice, but, we're put in a position where we have to do it twice.
And our engineers reserve the right to.
And if they want to disagree, they can disagree.
Absolutely. Right.
But we've already provided the testimony,
Okay.
we'll provide it again. So, Mr. Savage. Please address the comment made with regard to the need for downstream capacity analysis.
So, as discussed at the previous hearing, in the drainage area, which is contributing towards Afterglow Avenue drainage system, existing drainage system, the design is reducing the volume and rate of runoff towards Afterglow. That is achieved by the fact that with the building placed onto the site and the roof collected from the building, it reduces the drainage area going towards Afterglow. So that results in a volume reduction.
By how much?
I don't have that exact number in here. I think it was in a range of like an acre reduction of volume, but the volume is reduced. That's all in the drainage report that's been provided previously. In terms of Sunset, as previously discussed, the majority of this site, the building, is going into underground drainage basin, and then
Let me
there's
just tell you, so your testimony and the numbers to support your testimony are provided in the drainage report.
correct.
Which was submitted when, roughly?
Months ago, a couple months. I mean, there's iterations of it, but
January 11th.
So the testimony is, we're reducing runoff. A capacity analysis is not needed. If there's a disagreement from that, we should hear about it. That's the testimony, and it has been agreed to. So let's see if we can move on.
So you've only spoken about the runoff towards Afterglow. You were about to touch on Sunset.
Yes.
And my general question is, does your statement apply for all of the runoff for the site in every direction towards every drainage?
yeah, as discussed last meeting. So we have basically 4 drainage areas on the site going in different directions. 3 of those were reducing the volume and rate. That's the discharges towards Afterglow, to the towards the east, towards those adjacent properties, and onto Bloomfield, and then down towards Parkhurst. The runoff that's being directed towards Sunset, the majority of which goes through the underground basins, is reduced by or more than the DEP percentage reductions. So we have a rate reduction towards Sunset.
But, Mr. Inglesino asked you to say how much, and now you said, I don't know that. So you said more than the DEP, so how much, roundabout? And, besides the fact that you were also asked to rerun the numbers utilizing the standard.
Which is
We're going to get there. We're going to get there.
No, but I mean, the bottom line is, you don't know until you do that. whether
We've
the
already
one-
done that. We'll
Great.
get to that.
Well, that's not a public document. We've not received it or had a chance to
We're
look
going
at
to
it.
get there.
Thank you, Mr. Inglesino. I'm sure you will.
So with regards to the runoff towards Sunset, in based on the 2-year event, based on a 50% reduction or 50% allowable runoff, we would be allowed to discharge 3.57 CFS. Our proposed conditions is 3.5 CFS. In the 10-year, the allowable discharge would be 8.88 CFS, and our proposed is 7.91 CFS. In the 100-year, we would be permitted, in accordance with DEP, to discharge 17.11 CFS, and we're proposing 13.48 CFS.
Is that based on your new stormwater report or the former one?
Those numbers are from the former one. When we submit the new one, those numbers, I did send a draft.
Just say, what will the new numbers say? Will they be
The new
different?
numbers, we meet the same reduction requirements.
I mean, like I said, I haven't seen the new numbers.
You will. It'll be submitted.
So the testimony is that the revised report that you've sent a draft to the board engineer, but will be submitting, doesn't change the numbers as it relates to your testimony.
It doesn't change the result that we are meeting all the DEP quantity requirements.
So we're reducing runoff.
Correct.
So in your opinion, what possible purpose could a capacity analysis require?
In this scenario, I mean, we're reducing the rate of runoff towards Sunset, we're reducing volume and rate towards Afterglow, both of which result in less impact on the existing stormwater systems.
Okay.
Mr. Lucino, we're going to let Mr. Gonzalez, we might as well, while this is the issue.
Well, I would love Mr. Gonzalez to,
Well, we have the deference, so we're going to allow Mr. Gonzalez to speak about this point, and then it'll be finished, and then we can move forward.
okay,
Okay.
Thank you. I don't understand why there is a confusion as to the letter dated February 16. It is clear there that the item on page 8 is number 13, and then you see other parentheses that actually are citing Brightviews engineering comments. That's why, and I don't understand what the confusion is as to us endorsing or not Brightview engineering assessment. So definitely it's not. We're not endorsing Brightview. That's number one. Number two is that certainly the DEP requirements calls for 50% reduction and then 20% reduction, 25% reduction for the 50% reduction for the 2-year, 25% for the 10-year, and 20% for the 100-year storm. What happens is that Mr. Savage just gave up some numbers based on a model that was run on a unit hydrograph that happens to have a peak lower than the standard. Therefore, the numbers, I mean, they shouldn't be even given over here because we know those numbers are not correct. Now, in engineering, everything can be solved. That's true. And there is a reduction mandated by DEP. My point is I don't see a problem by saying this is the receiving pipe, has certain slope, this is the material. You estimate what is the maximum capacity running full, and you say, this is the maximum capacity running full, this is what is coming into from our side, and this is what is coming out in the proposed position, condition, and everybody's happy. So I don't see the complication just submitting that capacity analysis. It's very simple.
the capacity analysis has been submitted, has it not, Mr. Savage?
No, that was.
I'm sorry, not the capacity analysis, the runoff for you to conclude that there's less runoff and then the property is not nearly as impactful with regard to the capacity of the stormwater system as it is today, correct?
Correct.
So I guess, Mr. Becerra, if we're not going to agree to a capacity analysis for the sake of having a capacity analysis, the testimony from Mr. Savage is that there is a significant reduction in the runoff. It just is not legal, in my opinion, to require a capacity analysis when there is a reduction in runoff. And I don't understand the rationale as it relates to this applicant for why that would be the legal rationale for why that would be required. If the board engineer accepts the testimony and the reports issued by Mr. Savage, then I would conclude that there is no legal basis whatsoever to require the capacity analysis. But what I'm confused about is that notwithstanding a significant reduction in runoff, Boswell is still recommending a capacity analysis.
Well,
so I think
Mr.
that if...
Messino, paragraph 4 of the developer's agreement does provide that the redeveloper acknowledges that certain infrastructure improvements may be necessary in connection with the implementation of the project in accordance with the settlement agreement and the redevelopment plan. Redeveloper's sole cost and expense shall provide all necessary engineering studies for and construct and install all municipal infrastructure and capacity enhancements or upgrades required in connection with provision of water, sanitary sewer, and stormwater sewer service to the project. So I think that encompasses,
Well, no, that language you didn't read on, it's also limited by applicable law, which is the MLUL. And that language, which is section 4.3, which I negotiated with the town attorney for redevelopment, it was a statement of what the law is. If our project impacts adversely, if we need infrastructure improvements to supply utilities for our project, then we need to pay to supply that infrastructure. That's what that says.
well, how do we know that it doesn't, without having the runoff calculations?
You do have the runoff calculations.
Okay, hold on.
The testimony is that there is less runoff, significantly less runoff. Well, two things. One, this issue is not applicable to what's in the redevelopment agreement, because the redevelopment agreement, again, speaks to infrastructure which requirements that would be necessitated for the project, such as, for example, if sewer wasn't available for the project, we can't expect the township to pay for infrastructure improvements that we need for our project.
Right.
That is pretty standard operating procedure,
Absolutely.
and that is what the municipal land use law requires, and the purpose of that section is to make sure that that point is very clear. The municipal land use law does not permit, and we're not required to do any infrastructure, like just for the, for the benefit of the town.
Trumps the MLUL, we agree?
There's no inconsistency.
Well, we agree that the redevelopment agreement trumps the MLUL.
You can,
That the MLUL does not apply, in fact.
no, they don't say that at all.
Well, okay, we'll disagree on that.
Well,
But it
no,
does say-
as it relates to
it
land
does-
use, I don't think the redevelopment agreement gives license to Verona for us to provide, analysis with regard to things that
Well,
don't
let me just
affect our
ask you-
project.
Let me just ask you, it says, and install, the redeveloper and install all municipal infrastructure and capacity enhancements or upgrades required in the connection with provision of water, sanitary sewer, stormwater sewer service to the project.
Right, for the project. We
Well,
don't need additional capacity in your stormwater system
I understand
to
your point. Okay.
accommodate our project. We don't need that.
I understand.
And we are not adversely impacting Verona's stormwater capacity.
that's
In
the-
fact, we are improving it. That's the testimony and that's the report.
I don't
And
Testify, I'm sorry, on how you're improving the house 2 doors
we
down.
don't have to testify as to how we're
But what if
improving the
you're
house 2 doors
flooding the
down.
neighborhood?
That the testimony
That's,
is,
that's not your problem?
the testimony directly controverts what you just said. Okay?
Just repeat yourself.
I'm not going to repeat it. Mr. Savage, can you please again?
Madam-
That's not the point. You're arguing out of, he's talking about the developer's agreement now.
Well,
And
okay.
if you're saying, all we need is this sewer, and we'll put that sewer in for us. But if the sewer's not big enough to handle not only our runoff, but the runoff that's coming into it from the other side of the street, then we don't care, because our runoff is going in, and it's fine.
Infrastructure improvements to accommodate our project, that's our dime, that's our cost.
Agreed, okay.
We don't expect the township to pay for that.
Okay.
But there's nothing in this redevelopment agreement that obligates my client to pay for, for Verona generally. In fact, when you read the redevelopment agreement and other places in the settlement agreement, there are multitudes of representation from the township of Verona that Verona has adequate water, sewer, and all of the utilities to accommodate the
Well,
project.
okay, and generally speaking, yes, but it says redeveloper's sole cost and expense shall provide all necessary engineering studies for and construct and install all municipal infrastructure and capacity enhancements.
For the project,
This says that.
for the project, right?
Municipal infrastructure.
For the project,
Okay, it doesn't say for the
in
project.
connection with the project.
In connection with the provision of water, sanitary sewer, and stormwater service to the project, in addition to all required tie-in connection fees, et cetera.
Yes.
Okay. So it's your position that if stormwater capacity needs to be increased, that it is not the redeveloper's responsibility?
Our position is, that is not even an issue that is in this application. Our position is, and the testimony is, that it's reducing the impact on your stormwater capacity. okay? So the redevelopment agreement is really not applicable to this
Because you
conversation.
say it's a moot point.
Because the testimony from our expert who's provided the reports and provided the testimony is that there's a reduction in capacity. And what is, vexing a bit, to be honest, is notwithstanding that, we're still being told at our cost and expense to perform a capacity analysis. That is not appropriate, and it's cost generative, and it violates the settlement agreement, et cetera, et cetera. So if there's a justification for us to provide or perform an analysis, we're happy to do it. But when there's uncontroverted testimony that we are reducing stormwater impact on your system, then it just doesn't make any sense.
Mr. Gonzalez,
So can I ask a question real quick?
Is there a reduction in stormwater capacity, in stormwater from the site?
If they want to meet the DEP requirements, yes.
Okay.
I have one question for Mr. Saad.
Okay. So if they, please finish that thought, though. If there's a reduction from what exists now to what is proposed, are you satisfied that there is a reduction as Mr. Savage had testified?
Yeah, in order for them to comply with the DEP requirements, yes, they need to reduce.
And they have reduced?
They have to.
No, that's not the
I mean,
question. What
because
is
the
the
thing-
fact?
yeah.
What, have you had a chance to
No, I
evaluate?
mean, no yet, because the previous analysis was based on a wrong unit hydrograph that we discussed last week, and they need to come up with a new one with the unit hydrograph adjusted. May I ask Mr. Savage one question?
Yes, please.
How long does it take you to estimate the capacity of the pipe? If you know the inver elevation of the inflow and the outflow and the material of the pipe, how long does it take you?
I mean, I'm not sure.
You understand the question, you understand the question.
No, he knows what I'm talking about. How long does it take you?
I mean, look, we have a requirement, you just heard testimony from your own expert, that if we meet the DEP requirements, there will be a reduction in
But
capacity.
for the record, his testimony was he's not sure that it meets the DEP.
His testimony, let me finish.
It does not meet the DEP requirement.
Let me finish.
Because of the calculations.
Let me finish. His testimony was that if it meets the DEP requirements, then there's a reduction in capacity. We have a legal obligation to meet the DEP requirements. We will meet the DEP requirements. We have provided calculations based upon, whatever that we did. You've already heard testimony that under the standard method, we do. You've heard testimony that draft numbers in that respect have already been presented to the engineer. So the bottom line is, we will meet the DEP requirements, and your expert has testified that if we do that, there's a reduction in capacity. And notwithstanding all of that, he still recommends that my client spend money on a capacity analysis, which by his own testimony is completely unnecessary. And my legal opinion is it's not appropriate.
I'm sorry. I just want to bring some clarity. The issue is that because our engineer has not had the opportunity to review the revised and corrected report, we can't close this issue right now. We have not had adequate opportunity to confirm what is being testified here.
We have asserted, we have represented, we will meet the DEP requirements. That is going to be, if that is not clear right now, then you will condition an approval on that. And if we don't meet the DEP requirements, we can't get a building permit. We will meet the DEP requirements.
And when it comes
Francino,
to,
isn't he coming back next month to review his new stormwater management report that he's working on right now? Is that not true?
I'm not, right now, we're not talking about next month. What
Well,
I'm saying is.
the bottom
that-
line is he's testifying to something that we've not had a chance to review and this board needs to.
You haven't heard his testimony yet.
He just,
No.
you just told me he testified that he will meet, that he has met the DEP requirements. You just said, he just testified to that effect. So what are we supposed to do? We are
I
going
think what
to,
you should do is allow me to.
What should I do?
You should permit the testimony of the witness on the subject that we haven't covered yet to be made before you start to ask those questions. That's what we would.
but you're
appreciate.
jumping ahead. You're the one who just said, he did rerun the numbers.
Let me just say that we are not agreeable to providing a capacity
Mr.
analysis,
Inglesino,
we
and I'll
will-
give it back to the mayor.
we will agree to comply with DEP requirements.
So the reason why I consider this to be an open issue is the word downstream in relation to these improvements. I don't buy the argument that you can say that the utilities that are there are adequate for your project if the pipe 20 feet down the road is not big enough after it starts collecting from other inputs. Downstream capacity analysis. We need to know that all the way down to the trunk line that the system is capable of handling any runoff from your project. You may very well be correct, but we don't know that now. We don't have information on that, and we can't verify that engineering reports and analysis are not necessary yet at this point.
I don't,
My house, just for the record.
Please, sir.
I don't know whether what you're asking for goes beyond what the DEP requirements are. I'll ask Mr. Savage as to whether or not what you're asking for goes beyond what the DEP requirements are.
What I would say is basically, let's let our engineer review the report and review the revised report, and let's see where we go from there. All I can say is I don't feel we can close this issue right now. We've heard your witness's testimony, but with the lack of the time to review the foundational documents on which it's based, we can't say yes or no to we agree with you or don't agree with you. Okay, that's where I think this issue is right now.
All right, so Mr. Savage, now to move on to the Delmarva unit hydrograph issue. You had performed an analysis based on the Delmarva unit hydrograph model, for lack of a better, if I'm phrasing that right, is that correct?
Correct.
And an issue was raised as to whether or not that should have been performed pursuant to the standard unit hydrograph, is that correct?
Correct.
And you've had a chance to review that issue?
Correct.
And your conclusion is that the standard unit hydrograph standard is the one that should apply, correct?
Correct.
And have you run the numbers based upon that hydrograph?
Yes.
And would you please testify under oath as an expert to your conclusions in that regard?
And just to clarify, we're going to be submitting, we didn't have time from the last meeting, obviously, to submit this in enough time for everyone to review it. So I did submit a draft to the board engineer, but we're going to be submitting the final one coming up. So basically changing to the unit hydrograph, obviously there's some change in the flow. You're changing that hydrograph existing proposed conditions, and with the routings, some of the numbers, the CFS, the runoff increased in existing conditions. It increased, the allowable increased, and the proposed changed. But the numbers were of such that the size of our basins did not have to change based upon this change, and basically we're still meeting all the required DEP quantity reduction and rate reduction requirements. So that'll be provided with enough time so your professionals can go through it prior to the next time I testify. But that's the end result of that change.
Well, we've now had the testimony with regard to that report. We'll bring Mr. Savage back to provide further testimony and answer questions if the board engineer takes issue with the report. If the board engineer doesn't take issue with the report, then I don't know what the point of bringing back Mr. Savage would be.
Because the board ultimately has to approve the stormwater management. So the board might have questions, and to bring him back and simply update us, that's just, that's the way it works.
So we'll
You know that.
Well, if that's the way you would like it to work in this application, we will do that.
That's the way it's supposed to work. The planning board is the one
We
who
will bring him back to
ultimately
answer questions if
approves.
you would like with regard to his future report that's going to be filed, but you've now heard the testimony with regard to his findings.
Well, we heard testimony without seeing the numbers, so we'll wait.
Okay. Number 3, Mr. Savage, with regard to the project's water demand, could you address that?
Yeah, so as I discussed at the last meeting, we have had a number of discussions with the township engineer, and we are we are aware of the fact that a number of the wells have been offline, and the plan is to do our hydrant tests once those wells are back online, so we know what's going on in the water system there. And basically, we'll continue working with the township engineer and to determine, if basically once we get those tests, we'll know about the flow and the pressure at the site, and then, if we needed to install a pump for the building, then that would have to be done.
We will agree to do that as a condition of approval, not a problem. Number 4, project's fire flow.
Yeah, I kind of sort of ran into that one in my explanation for number 3, but basically this is related to the hydrant flow test, which again, we're waiting for the wells to be back online before we do that test. If the results of those tests find that the pressure is less than the 20 pounds per square inch, then a pump would be needed, and that would be provided as part of the MEP designs.
Okay, and number 5?
Number 5 really, I think, is the statement about the factor of 2. We, with sanitary, have been also in discussions over the past number of months with the township engineer. Per those discussions, it's our understanding that there are no conveyance issues and that the sewer treatment plant has adequate capacity. We're going to continue those discussions with the township engineer regarding our sanitary sewer connection. We ultimately obviously have to go through a treatment works approval process, which would require township sewage authority approval.
These are issues that are addressed post-approval by the board, correct, in the ordinary course?
Correct.
And then the last paragraph, can you address that?
So I guess this is still under number 5, related to the request for a capacity analysis. We had, over the past number of months, have been working with township engineer regarding sanitary sewer. At one of the earlier,
just so everybody's confused, this is not stormwater. This is sewer capacity.
This is related to sewer capacity.
Different capacity.
Yes. And so, in this comment here, the Boswell letter, they recommend a 4-week flow monitoring performed on one of the manholes downstream of the site. In previous discussions with the township engineer, and I believe it's mentioned at one of these previous hearings, our discussions with the township engineer was to agree to jetting certain sections of the sanitary sewer main that's out in Afterglow. I believe the lengths were from Sunset along Afterglow up to Afterglow Way, and then up to the end of Afterglow, which would be jetted and videoed to see if there's any issues on that main. And again, per those discussions, he was not aware of any known capacity or conveyance issues with the mains located within Afterglow and downstream of that site.
Right, and again, there is a settlement agreement with Verona, in which Verona, I know Mr. Gonzalez may not be aware of that because you're new to this process, there is a settlement agreement with the Township of Verona, and the Township of Verona has made very definitive representations with regard to sewer capacity, water capacity, and the like. And so, we push back a little bit to say that, we think that covers any kind of capacity. Again, I think it would be cost generative, inappropriate, and not consistent with the settlement agreement to require analysis with regard to issues in which we have very clear and definitive representations from Verona. And I think I have I'll point those out to Mr. Massara. I don't want to go through them now, but that would sort of be our view of that.
Mr. Messino, can we agree that there's a difference between general capacity and the capacity of a pipe in the vicinity of the project? I mean, Verona I was not party to that, obviously to those proceedings, but if Verona made a representation that there's adequate sewer capacity, doesn't that apply basically to the sewer plant and the ability to handle any excess flow, but not particularly, especially with the language that I cited before, not particularly with pipes in the vicinity, and just existing sanitary pipes in the vicinity?
in our discussions with the township engineer, he was specific, one of his comments was regarding conveyance, the actual pipes leading to the sewage treatment plant. He said there's no known issues with the conveyance pipes, the township pipes in the streets.
Well,
And that's why and to further that, we agreed at that time to jet and video certain segments in coordination with him.
well, Mr. Savage, can't we agree that the condition of the receiving existing sanitary pipe is important to this project?
And that's what I was just discussing. So the conversations with him was that those pipes that we're connecting to, that's called conveyance pipes.
Right.
There's no known issues in those pipes. Regardless of that, we also agreed to jet, which means clean out, and video those lines to confirm the condition of those pipes. So, I mean, we are doing that.
Or do they have the capacity? They could be brand-new, wonderful pipes. Do they have the capacity to handle the...
Again, based on conversations with him, he said they have adequate conveyance.
Okay.
Yeah.
Adequate conveyance.
That's capacity.
Now, I'm not an engineer, and I may defer to Mr. Gonzalez, but the engineer said there's adequate conveyance. Do we just, based on what?
I mean, that's the township's professional saying that.
Right, but isn't it your obligation?
Not this,
No, I mean,
Isn't it your obligation to show that there's adequate, that there's adequate capacity?
our typical submission would be to the township to get their approval on during our treatment works approval process. I typically, rarely have I ever had to do a downstream sanitary sewer analysis, and that's being asked for. Traditionally, it's going to the township to get reviewed, and they're the ones who know about any kind of conveyance issues.
Mr. Savage, for a project this size, what size sewer line do you think would be adequate for your project?
I mean, right now, we provided a sanitary sewer report, and that report, the laterals from the site, which is actually the Brightview review letters had requested that we confirm the size of the lateral was appropriate. So we did that analysis in that report we submitted, and the 8-inch pipe, a lateral in that scenario had about 6 times the flow that we had. So it was able to handle 6 times the flow that we were putting into that pipe.
Yeah, and so you're saying the size pipe coming off of your property is going to be what size?
Right now, it's an 8-inch. I mean, that's going to be subject to our discussion with the MEP engineer when they get involved, but it's an 8-inch. We provided calculations for that capacity.
Okay, that's coming off of your site, and what size pipe are you tapping into?
The one we're tying into is an 8.
Okay, so you're saying you're adding an 8-inch sewer line coming out of your building and tapping into an 8-inch line in the street.
Yeah.
And you're saying that's adequate, being that there's an 8-inch line currently serving the neighborhood? I'm sorry.
I didn't catch this one.
So you're saying that you have an 8-inch line coming off of your project, and that's adequate for your project?
It's not adequate.
If I may.
And you're
because-
tapping into an 8-inch line that is currently in the street that serves that entire area of Verona?
I don't know the exact, the extent of that, but that's a standard tying in an 8-inch to an 8-inch. That's standard. That's not
Okay.
unusual in any way.
Of course, it's not unusual, but you're saying the capacity you need is an 8-inch line.
No. What I said was we're proposing an 8-inch line. That's based upon preliminary discussions with the architect. So there's different sizing for laterals based upon building code and based
Of
on
course.
flow. The
Of course.
pipe that we're proposing is, as I mentioned, it could handle 6 times our flow. So it's not sized for our flow. It's
Let's say this, you build a bathroom, you use a 1.5-inch line for a sink, a 2-inch line for a shower, and a 3-inch line for a toilet. So you're saying you have an 8-inch line coming out of a building that's going to have 200 units. That's, I think, would be the proper size for a building like that. But you're tying into an 8-inch line in the street. How do you think that is going to, you don't think that's going to overload the capacity of that 8-inch line in the street further down the line?
No, well, I don't know. Ultimately, I'm not sure of the exact change of where the pipes increase, but But yeah, with that 8-inch pipe, again, and we've been in
Mr.
discussion.
Savage, are you able to testify as to what's going to happen down the line, whatever that
No.
means? Okay, so let me try to bring some rationality to this. There's a settlement agreement.
Yes.
The settlement agreement that was approved by the Verona governing body. I'm going to read from page 7. It says the parties acknowledge that low and moderate income, I'm going to read a relevant portion, but it's in context. The parties acknowledge that the low and moderate income units contained within the project renders the project an inclusionary development and provides it with all of the rights, benefits, and protections of an inclusionary development, including but not limited to the township's obligation to provide adequate public utilities and services, water and sewer, to the property, as well as the prohibition on cost-generative development standards or requirements. The reality is that the township engineer will have to sign off on the capacity issues through the TWA process. And our position is, per the settlement agreement, that if there isn't adequate capacity and if the pipes don't work, that's Verona's obligation under the contract that was signed
Well, Mr.
between
Armstrong,
us and the township.
the redevelopers agreement says, which was signed after the settlement agreement, says that the redeveloper, et cetera, construct and install all municipal infrastructure and capacity enhancements or upgrades, enhancements or upgrades required in connection with the provision of water, sanitary, sewer, and stormwater.
It says in
sources.
accordance with applicable law, and this is a Mount Laurel settlement. That's where you're,
I disagree with that. No, I mean,
it doesn't say in accordance with
Then
applicable
what's
law?
the purpose of this language?
Well, I'm
The
telling
language
you,
has to have a purpose.
I'm telling you what it is.
No, well, I think this language came after the settlement agreement. So I'm not sure that we have an issue yet, but I think this board has a legitimate request to say, hey, what's going to happen? And if the redeveloper agreed to construct and install all municipal infrastructure and capacity, okay?
For the project, Mr. Massara, Mr. McAvoy is asking about what the impact that has on others, on
Well, if
other
it's just to the
parts.
project, then why would the redeveloper construct and install municipal infrastructure and capacity enhancements or upgrades required in the provision? You're saying just for the property?
Yeah, for the project. That's what it says in the redevelopment agreement. The redevelopment agreement and the settlement agreement are not inconsistent. If there was not adequate capacity to provide for our property, to provide that service to our property, that would be up to us. But Verona has said that it has adequate
Well, when is
capacity
sewer
to
capacity
develop
ever-
it to the property.
When is sewer capacity ever limited to just the site? Of course, your site will have sewer capacity. I mean, sewer capacity is not contained within a specific site. Sewer capacity means capacity to travel through the municipal system and to be treated, and to adequately travel through the system.
mean that.
Well, how could sewer capacity have anything to do with the site in and of itself?
I'll tell you how.
Okay.
Because sewers are limited, sewer utilities are limited and permitted with regard to the amount of sewage flow that it can accept. And if your sewage facility is at capacity, it can't accept any more sewage, then that's how. It's not just the ability of the conveyance system to handle the sewage. Your treatment facility has to have the permitting to be able to, right,
And
so.
if it didn't, or if the pipes didn't, why does this say that the developer shall construct the upgrade, shall construct and install upgrade?
Because if there was a pipe that was necessary at the property for our site, a pipe, that would be on us to do.
We
But-
agree to
but-
we agree to disagree. I understand your
But we're under no obligation to improve Verona's municipal infrastructure. That's not what we're obligated to do.
understand your point, respectfully disagree at this point, but
I just want to make one clarifying statement. There was some discussion as to what was said by Verona's township engineer. Two things were said. One thing I heard a couple of times, no known issues, and I heard a couple of times adequate capacity. So if Verona's township engineer has made any statement, we should differentiate between the two, because those are two different things, whether there are no known issues with the sewer line or adequate capacity. Adequate capacity to me involves a calculated and measured knowledge of the flow. No known issues means we haven't been called out there for backup.
Respectfully, these are not, the board is not charged, or it's not the board's role to, your role is to say, if there isn't capacity, right, so there's case law on this, the Fields case in particular, which is pretty well known in the land use section, right? So if you are an applicant and you're coming before a board for an approval, and there's just no way to provide utilities for your project, right? You're not in the sewer system, there's no reasonable way you're going to be able to get sewer service, then a board can say, we're not going to approve your application because it's not realistic that it's going to be built, right? That's the Fields case. The issue of whether or not these capacity issues are issues that are not decided by this board. They're issues that are decided by your municipal engineer, who has to review and sign the TWA. And if there's a problem, that's the person who's going to say it's the problem. It's not within the province of this board to
We
be.
agree to disagree.
I'm just telling you as a matter of law.
Well, as a matter of law, we're not going to be making the determination for you to increase a pipe. It's going to be our township engineer. It's going to be those people. But do you not think that the community and this board have concerns about overages? That's part of the overall job of a.
We're testifying as
Thank you.
to our
Thank
project.
you for interrupting again.
Well, it's beyond the scope of the authority for this board to be making engineering decisions on capacity. It just is.
I respectfully disagree. That with the site plan application, the board should consider all issues that are presented in the site plan. Runoff, sanitary sewer is part of the site plan.
Right,
The
as
board-
as it relates to our project and our property. But, properties that are off-site, no, I think that's way beyond the scope of what the board's authority is.
Again, Mr. Lucino, we go back to all municipal infrastructure and capacity. So, but I'm beating that dead horse.
And I'm just going to add this. I have to strongly disagree, because there's other projects outside of Verona that were a greater number, and I'm not going to name them, but they dug up streets and they increased the size of the storm drains and the sewer pipes to connect to the Verona sewer system. And when we talk about we have the capacity, we are 100% talking about the sewer treatment plant. We are not talking about the infrastructure underneath, because we, from the township's perspective, council-wise, had no idea what the size of those pipes were. That's why the verbiage that Mr. Massara read is in those agreements.
I can tell you that there's nothing in these agreements that obligate us to, and in fact, it would be a breach of the settlement agreement to require this applicant to fix or enlarge Verona's infrastructure. We are going to make improvements that are required to accommodate our project, and that's it. And that's what the law is, and that's what the agreements provide. So, these off-site capacity analysis that you want that have nothing to do with our project or providing services for our project are not appropriate. And they are way outside the bounds of what the board can require. And, that is my legal position, and, I don't have anything else to say other than that. I think that's just way beyond the bounds of the board. So I think that concludes the topics to be discussed by Mr. Savage, unless anybody has any further questions for Mr. Savage.
Questions for Mr. Savage. Mr. Savage, in your first stormwater report, and obviously as was generated through a myriad of our discussions at the last meeting, there was a small portion in the upper right rear of the property that is in Montclair that you are installing some sort of swale or non-green infrastructure. You're going to be doing some disturbance there. So my question to you and perhaps to Mr. Inglesino, I'm sure he'll take over, is are you required to go before a land use board in Montclair in order to do that disturbance in Montclair? And this board has a right to know because it could change your stormwater management on the site that affects Verona. So,
The answer is no, and there is a provision in the settlement agreement, if you want, I'll find it, that specifically says that to be able to do this project, we don't have to go to Montclair.
did Montclair sign off on that? I mean, I just don't understand how that could be so. If you're disturbing property in Montclair, how could Verona give you the right to not go to Montclair? I'm curious, legally speaking, just a question.
Because the board could not impose conditions on the project that would trigger our requirement to go to
I
Montclair.
think the question more
Really?
specifically is, do you have any obligation to Montclair in any regard with regard to this application?
No, and frankly, we addressed that the very first evening of our testimony. So
I really
we're happy to
didn't-
address it again, but the answer is no.
So you're allowed to disturb and install certain non-green infrastructure on Montclair without going before their land use board?
There's only grading on the Montclair property. There's no structures, there's no anything there.
Didn't you say that there was going to be the installation of some sort?
That's grading.
I know what grading is, thanks.
It's not installing, it's not installing, it's grading.
Where is your non-green infrastructure going to be installed, the non-green specifically?
All over the site, but that in the rear there is a swale.
Would that be cement?
It doesn't,
Non-green? I mean,
there's no requirement, anything that's non-green infrastructure, it's not like we have to put it in an easement, or, I'm not sure what you're asking. It's grading.
Listen, I would like to get a question out without getting run over, really. Bottom line, you in your stormwater management report, the last one that I have, it says the installation of non-green infrastructure. And you said it in regards to a certain area on the site. What area on that site?
The one area is, there's a swale towards the east side in Montclair, behind that, on the east side of the building.
In Montclair. So,
In Montclair, yes.
so the grading in Montclair is, what you're calling grading is, you're considering grading non-green infrastructure? Is that what that is?
I mean, it's great.
Regrading of property is quote-unquote non-green infrastructure in your measure? Is that what
I'm
you're?
not sure what you're getting at, but we're grading in that area. It's grading. I'm not sure what's the
You
distinction.
referred to it as non-green infrastructure. What exactly is that? Can you please define it?
It's a graded area where water can flow down. There's
So in
not
other
much you
words,
can say.
non-green infrastructure is regrading. Is that what you're saying? You're
I think-
making
I
them
think-
Green
synonymous.
infrastructure has no-
Help me out, Mr. Inglesino, because I'm not getting an answer.
Right.
I don't understand.
I think the question was, does that area trigger the requirement to go to Montclair?
That was the first question, and you just decidedly said no. But now I'm asking about non-green infrastructure, and I'd like it defined, and he's saying grading. And then I said, so non-green infrastructure is regrading, is that what you're saying? And he's like, no. So which is it?
I think the expert is here to testify with respect to the plans. What he has said is that the area that you're described represents regrading. I'm not sure what else he's supposed to say.
He used terminology in his report. If he can't back up what that terminology is and what it means,
What would I be backing up? It's grading in Montclair. I was referring to it to make it a distinction between the swale that's on the south side of the building meeting the green infrastructure requirements. I'm not
it's
sure
a
what
term
you're
that
trying
you
to-
used. I've never seen that term
Exactly. I've
used.
answered this multiple times here.
I think he's saying that the
Well, I
swale.
guess I'm just not smart enough to grasp what you say.
I think, Madam Chair, that if I.
It's just ridiculous. Then answer it
I
again
have answered it
clearly.
multiple times. We are grading on
The testimony was, and Mr. Savage will correct me if I'm incorrect, is that the grading.
Really getting upset because this is just beyond the pale.
May
You
I-
want me
may
to
I
act
just-
like beyond the pale moment? It's ridiculous.
The testimony was that the grading in Montclair is not green infrastructure, okay? That was the testimony, okay? And that the other grading that was referred to on the south side is green infrastructure. Is that correct, Mr. Savage?
Correct.
That's all that was being communicated. I hope that answers your question.
5-10 minutes later, maybe I'm just going to ask
Well,
you the
then just-
engineering
Let's just
question.
move on.
Exactly
because
how
this
I answered it.
Colloquy is just wasting time. If he answered the question, he answered it. If he didn't, then let's ask a follow-up question, but let's not argue about this.
The hydro pump. You mentioned a hydro pump. What exactly is that, and what kind of room does that take up if you need to install one?
Excuse me?
You mentioned if we need to, it's in your document. You mentioned if you needed,
Hydro pump? That's what you said, I'm not sure. Well, what I was referring to is if based on the water pressure, there needed to be a pump in the building, yes.
and my question is, what kind of room does that take up? What kind of,
That's architectural. There's rooms that they have, a mechanical room.
so
that
it's a
would handle
big,
that.
it's
No,
big.
no, I mean, we can refer to, when the architect comes up later, he can refer to, no. I mean, it also depends on how big that has to be. Like, what's the pressure in the street versus what it needs to be for the design. I mean, that mechanical, the MEP design has not been done yet, so, but there is room within the building for a pump room. These are not large rooms. It's not a large development.
Right, and the testimony before was that you can't do these tests because you don't even have your wells online. Those tests will be done in the ordinary course post-approval, and the testimony from the beginning of the evening was that if there were pumps necessary, that there would be pumps.
Let me say something to help move this along. Other buildings within the Township of Verona have booster pumps in them. The Township of Verona operates its own booster pumps. In general, these are not, huge machines for a building this size. We have one that's in an underground vault. So I don't think, if he's making a statement that they have the ability to accommodate whatever pumps are required within the building, I think that that's reasonable.
Yeah, I wasn't asking whether there was room. I just wanted to understand what it would take to install it into your building and how much room it would take up. I wasn't questioning whether you had the capacity.
Well,
Unlike the other.
well, no, I think you were, yeah.
Do you?
Yeah, I do.
Okay. Does anyone else from the board want to ask any questions of this applicant?
Question on the downstream capacity for stormwater runoff and the downstream capacity for sewer. Are those pipes in any way connected?
No.
No. So they're completely separate?
Yeah,
systems?
the connection for sanitary is off of Afterglow. That then flows down Sunset away from Bloomfield. The drainage is down closer to Bloomfield. We actually tie into basically the last structure before it reaches Bloomfield Avenue.
And the stormwater runoff, where your basins will collect into?
Yeah.
And where is that pipe? And where does that go into, like the street sewers or the?
Well, the one, the largest drainage area in the post conditions is from the roofs, and that goes into the underground basin, and the lower parking area goes into another underground basin. Those discharge to a manhole that's just off of Sunset, and then that's that last run, and then it hits Bloomfield Avenue.
Okay, to that manhole, right, and so there's no connection between those. Okay. Since you gave your strong opinion, the board will entertain me. I'll give you mine. Sounds like the settlement agreement says we are obligated under the settlement agreement to give you the necessary municipal sewer supplies to build this, right? So we have an 8-inch pipe for you, which you have said is 6 times adequate. That's our job, and sewer to maintain it. Just like stormwater runoff, and per what I believe, the language that I just heard, the redevelopment agreement supersedes that and extends it, is that changes needed to your capacity, your sewer runoff, you're obligated to not just get rid of it through our pipes, but to maintain the neighborhood as it is. And that's our job to make sure that's the case. So my opinion is you're on the hook, your dime, for what runs out of that.
we're not obligated to maintain the neighborhood. We're obligated to comply with the DEP regulations that are applicable to the project. And those DEP regulations will require a reduction in the rate of runoff. Isn't that correct? Correct. And that's been the testimony. And so the neighborhood will benefit from a stormwater runoff perspective
I understand.
as a result of this project. That's one of the benefits of the project for the neighborhood.
But you're denying any obligation for your sewer runoff in a more recent
Well,
testimony.
there's not sewer runoff. The
Sewer discharge into said pipe.
Well, no, what we're saying is that, there is, it's Verona's obligation to ensure that there is sewer available to the property.
You got an 8-inch pipe.
Oh, okay, so, I mean, I don't see what the issue is, but what we're also saying is, it is not our job or our responsibility in any way, shape, or form to make upgrades to Verona's infrastructure that are not necessary to accommodate this project.
If I could, okay.
Go for
I
it.
just checked because you had said something before about off-track improvements, and developers certainly, in instances, bear the cost of off-track improvements. And, there's case law that I've just reviewed that confirmed my belief that there are many instances when a developer is responsible for off-track improvements. So I just want to put that on the record.
Well, but let's understand what the case law says. If traffic is a classic example.
Well,
If
traffic
they-
is generally different, and that's the way traffic is handled differently than off-track improvements. Generally speaking, if the township has an ordinance, okay, then the developer will pay a proportionate share, okay, for the cost of the off-track improvement that is deemed necessary because of that development.
That's the key. There has to be a nexus between what is being required
Absolutely.
and the development, okay? We are not doing a capacity analysis. We are not upgrading the infrastructure for the township of Verona. We are building a project, and we will incur costs that are
Well,
necessary.
if that project results in the need for infrastructure to be upgraded, then that cost can be passed on to the redeveloper.
That is not a true statement as a matter of law.
Nunziata, okay, which I just read, and respectfully, I happen to argue a case and win in the appellate division on that very issue. And so I can even send you the case.
Yeah, well, look, okay, so schools, right? If you're building a project that's going to bring in more schools, you can't require the developer to pay the school board.
That's not infrastructure.
Or to pay, or
That's
to
not
fund.
infrastructure.
Well, you got to build, you
That's
got to
not
build
infrastructure.
schools,
That's not infrastructure.
okay?
Right, okay. All right, just, I mean, obviously, we're not going to resolve that tonight, but.
You are replacing a school with a residential building. If you are generating more sewage flow out of the school, which I'm going to say is highly likely, more sewage flow than what is existing, and it is more than what the trunk line in the street can handle in addition to the neighborhood flow it is already handling, then that says your development is having an adverse impact on the neighborhood and might require an off-track improvement. So,
Right, I guess,
you might not agree, but you're saying that this is not a land use issue. Okay, well,
Look,
this board chose to push this back at you and you didn't like it, you can go back to the township.
you
right?
can't have these discussions in the abstract, okay? These are fact-specific.
Right.
These cases always.
But you don't want to do a downstream flow analysis, so we don't have facts to be, that's the thing. If you did the flow analysis, it would answer the question as to whether, what the facts are in this case.
You brought up the abstract.
No public at this time.
You're talking about sewer, or you're talking about?
Sewer, not. There was a request to do a 4-week sewer monitoring in a downstream manhole from the project. You said, we are not willing to do that, that's cost generative, it's not justifiable. But at the same time, we're arguing as to whether or not your project is going to overrun the capacity of the existing sewage trunk lines that are serving that neighborhood and that currently have much less demand on them from a school versus a 200-unit residential development.
I don't think there's any, Mr. Savage, is there any, what is your opinion about that, if you have one? Are we going to, is our project going to require all new infrastructure in Verona to widen the sewer pipes? I mean, I don't know what the question is.
I can't opine on that without studying it. but-
In the area,
This is
seriously,
again,
you know.
what I'm getting back to is that we can't settle the issue, is it? We can't say, no, you're not going to have an adverse impact on the neighborhood, because we don't know. And so it's a question of, if you are going to have an adverse impact on the neighborhood, if people do start getting sewer backups. And remember, I mean, it's not a long ways downhill from your building down towards Bloomfield Avenue. So it's not like we're asking you to redo all, we would be asking you to redo all of the pipes in the neighborhood. It would be only what's downstream of your building, if in fact you were to overwhelm that. So without the flow analysis, we don't have an answer.
All right, let's hold that one for now, Mr. Mayor.
I'm sorry.
Thank you.
We Boswell typically review this type of projects all the time. And the recommendation is made because there's definitely going to be an impact on the receiving pipe. So say, in addition to that, if, say, DPW reports that there is some backflow, so we also suggest to video inspect the pipe to see if it needs to be replaced. There is an impact on that, and it is a good practice, and it's a suggestion just to run that, because adequate capacity can be only set or affirmed if you have the numbers, because flow is a variable that is measured. So in order to you to say adequate, you need to have a number.
Facts, Mr. Anglicino said.
Yeah, there is no way to know what this one thing is that the capacity of a pipe typically is estimated based on the pipe material and the slope. To calculate that takes a minute, because you have even online calculators that you can perform that. Less 30 seconds. So the flow monitoring is going to allow you and the town to determine whether that receiving pipe is going to have enough capacity to receive a flow that was estimated to be 56 gallons per minute that you're putting into the existing pipe. If I were you as a builder or developer, I would be worried if the receiving pipe has no capacity to accept all the flow that I'm generating. As we speak, I'm designing, for example, I have many cases, I'm not going to mention the towns. As we speak, I'm designing a pumping station in another municipality up north. And we are changing a wastewater treatment plant into pumping station, and we are discharging into another town. And without the town recommending that, I performed the capacity analysis of the receiving pipe, and they gave me also the capacity of the receiving wastewater treatment plant downstream. But that's what I would do. That's my opinion. It's a good practice to perform that, even if you are not required or requested to do so.
So let's hold that question open for now. We'll have to address it.
That's fine.
Mr. Anglicino, did you at all, I know that there are a lot of things that are I know that there are a lot of these comments from Boswell that are going to be addressed upon the resubmission of a new stormwater management report and any other potential site plan changes that would have to be made to accommodate new stormwater, right, of course not. But well, he shook his head no, so I said, of course not. So did you want to address any of these statements and these comments that Boswell made from the standpoint of the engineer? some of them are obvious that.
I mean, I think a lot of it might be better to submit the revised report. I mean, it's, and then let the board engineer review it and then come back with comments again at that point.
All right, but there are utility comments here. We're not just talking about stormwater. You know, you can kick them to maybe Mr. Raker or something, but I thought that they would be for you.
Yeah, I mean, we are planning to do a resubmission on this, on both of their review letters and.
So it's just going to be a game of tennis, like back and forth with review letters? Can
That's
we?
standard is how you do it, yes.
Yeah.
But I mean, if there's something specific you want us to go through, let me know.
Well, I mean, if you're going to resubmit with comments that address these,
That's the plan, yeah.
then fine, then we can talk about that in April.
Or, I mean, depending on when we get it in, if there's going to be enough time for everyone to review it before April.
All right,
Sure,
well,
yeah,
maybe May.
It'll be discussed at another.
Right. I'm sure you'll let me know when you think it's appropriate to hear that new stormwater management report. Right?
Yes.
Okay. You have more questions?
No, it's a comment that I would just make in the cost of the four-week flow monitoring typically ranges between $3,500 and $5,000, so it's not that expensive. Yeah.
Any other questions from the board? Great. No questions from the engineers? No comments right now? At this time, we'll open to the public for questions for this expert on any of his testimony from this meeting or last meeting. Please state your name and address for the record.
Hi, guys. Jonathan McElroy, 76 Sunset Avenue, Verona. First of all, I'd like to apologize, everybody in the room. It was hard to contain myself, so please accept that. Okay. I'm curious why the owner-operator isn't here tonight to talk about some of these issues, because he stated that he wants to be a good neighbor and will be with us for the long haul.
Right, these are questions for Mr. Savage's
Correct, I'm getting
testimony.
that. Can you please illustrate, Mr. Savage, where the downstream actually is? Like, are we talking about the flow to Bloomfield Avenue? Or are we talking about the flow down to Sunset that curves around to get to Mount
I mean,
Prospect? Is it Afterglow? Like, where is this stuff
There's a
at?
number of them. In the drainage report,
Mr. Savage, please wait until he's done with his question before you start answering.
I'm just curious, like, everybody keeps talking about downflow and calculations, and I'm very interested in that. But where is everything going, right? Is there an illustration showing us, hey, stormwater is going to go down, it's going to come out of your parking lot, it's going to make a right-hand turn, it's going to sit at the traffic light for 8 minutes, and then it's going to go to the right. So I'm just curious, like, where does everything go? What is it? You're talking about sewage tying into certain lines, you're talking about stormwater tying into certain lines. Like, where are those lines in relationship to the streets and the geometry of this little neighborhood?
so
Well, hold on, you're talking about stormwater or sewer?
I'm talking about both.
Okay.
We can take one at a time.
yeah,
let's
so
start with sewage.
stormwater, I mean, we've submitted site plans, all that's detailed on the site plans. We've submitted a drainage report, all the drainage areas and where the runoff leaves the site is all detailed on the drainage.
Mr. Savage, Mr. Savage, if I could, Mr. McElroy lives next door to the site, okay? He's just asking you a question, not in technical terms, but of you. Where's practically speaking, where's the water?
Where's your house, Mr. McElroy?
I'm
relative
at
to the site?
76, so if you walk out of the driveway,
Right.
okay, you make a left on Sunset Avenue, and it goes down and it goes all the way to the bottom of the hill. I'm one of the guys at the bottom, makes a sharp hand turn to Mount Prospect.
So you're down, yeah, so,
I'm towards the golf course.
yeah,
if
so.
you know where that is.
So the runoff from there would be, there's sort of a high point in Sunset. So The runoff that would ultimately get down towards you, let's say, would be the drainage area that's going towards Afterglow. As mentioned in some of the testimony, we're reducing the volume and the rate of runoff going towards Afterglow based upon mainly the fact that the building is sitting on that site and all the roof collection is going into the underground basins and getting discharged down towards the bottom of Sunset near Bloomfield.
So meaning the water is from the basin that you have under the building is being diverted to the right. And
Yeah,
that short
down.
little spur to get to Bloomfield Avenue towards the Montclair side.
It's being piped into the existing drainage systems that are within the right of way of Sunset Avenue.
I'm sorry, forgive my ignorance and confusion, but so the basin underneath,
Mhm.
the retaining basin, whatever
Yeah.
you call it, that's filtering water out.
No,
Or
that's a
it's
detention,
piping.
those are detention systems, so those are piping it out.
So the water at the top of the roof that gets collected, all the crazy rain, and it comes down and it's coming through the roof, down the gutter system, into a system, where does that get out?
That gets piped, ultimately goes through, it's detained in there, so the flow is slowed down
Mhm.
time-wise. It ultimately discharges from those basins to a structure, an existing structure that is right near the entrance drive, the lower parking area, and then it goes down to
To
the
Bloomfield,
Avenue.
and then down the hill and wherever the hell it goes
Yeah.
from there. Okay.
No, that's in a pipe, that's not,
Correct.
yeah.
And that's everything that's collected on the roof?
And the parking area, so the
parking,
entrance
okay.
drive parking area, that flows to a trench drain that goes to the underground basin in the lower parking area. The lower parking area also has a trench drain and inlets and stuff,
Mhm.
that goes into that basin too.
Yeah, I'm familiar with trench drains because I had to put them in because I'm
Yeah.
at the bottom of the hill. So what is the impact of your building and structure for the opposite direction?
It actually improves that because by putting that building there, what underneath that building would have been the grass or whatever, or actually the parking lot in the back there, that would have flowed overland, ultimately getting, a lot of that would have gotten onto Afterglow and into that system. We're reducing the drainage area that is flowing towards Afterglow. That ultimately gets collected in some inlets there and then flows down towards your area. So that flow isn't just in the street and then goes down towards your house. It's in those pipes and goes down that way. There's a ridge sort of on Sunset.
Yeah, oh yeah, I'm
Yeah,
familiar
yeah.
with
So,
that.
so near our site, and that's,
Okay.
so we're reducing the volume of runoff and the rate going towards Afterglow, which ultimately gets into pipes going past your house.
Okay. This may be a question for you and/or the board or the council, I'm not quite sure. Currently, I've witnessed, I would say at least 4 times a year, that a significant rainfall, I don't know if that falls into a category of a 1-year storm, a 2-year, a 10-year, whatever the hell it is, where the access panels, I guess you would call those manhole cover, basically explode out of the ground with stormwater gushing. So how does, I guess the question maybe for you guys
No,
is.
you have to ask.
Sorry, all right, question for you. Do we
You don't want that
know
one?
if there's a suitable capacity right now? Is the system able to handle the current situation? And how does your development impact the existing condition?
Are you qualified to discuss the Verona system generally?
What's that?
Not the existing system.
Would that fall into the category of downstream? Maybe I need a definition of what downstream means. Can you please answer that question?
I think what the testimony was, these issues are regulated by the New Jersey Department of Environmental Protection. They promulgate regulations, and there is a requirement on the applicant to comply with those regulations. And as the testimony has been, those regulations reduce the rate of runoff.
So who can answer my question?
Well,
Do I need to call the DEP and ask them the question?
no, but you're asking a question about Verona's system that is not part of the
I beg
testimony.
your pardon,
that
but
was
I'm
provided.
asking the question of how your development impacts the existing conditions.
Right, and he's
And
answered
you're
that.
telling me, oh, it's going to reduce this.
He's answered that, and he'll be happy to answer that
Yeah.
question.
But
So again, if there's an existing issue
There
with your
is.
system, but no, so I'm just saying in general. So
Agreed.
if there is, what our,
I apologize. Again, sorry.
our requirement per DEP regulations is to reduce that rate of runoff to avoid any impacts to the downstream or off-site areas. We comply with all those requirements to DEP. And in fact, towards the water, towards afterglow, which is getting into the pipes that ultimately go past your house, we're reducing volume and rate in there. So we're improving that situation. I'm not saying that our improvement is such that it would, void all the existing issues, but it is not exacerbating those. It's not making any of that worse. It's improving it to some extent. We're only one property within the whole drainage area there. But we're required by the DEP to improve the condition, reduce the amount of runoff leaving that site. So to whatever extent it would be, we're improving that situation.
So,
Again,
I mean, that sounds amazing on paper, and I'm not being a dick here, I apologize, excuse my language. That's a fifth apology. It sounds great, right? Like, okay, you're coming in, you're actually improving conditions for a bulk of the neighborhood. What if that doesn't actually come to fruition? Then what? Like, who do I talk to about that?
If there is an existing issue on those drainage pipes, I mean, that's not our responsibility to meet the regulations that we have to, is to reduce the runoff, the rate of runoff going towards that, and to not increase any issues that are in that system.
Correct.
That we're doing.
Correct. So if, for whatever reason, you do increase
We're not.
flow.
We've provided.
But that, all right, on paper, that's great, but how do we check this?
That's why,
Throughout time.
because
Like,
you're.
who does that? I guess the question.
Well, you're asking two different questions, I think.
Okay.
One is whether the engineering supports the testimony provided by the applicant, and your board engineer reviews the plans to ensure that what the applicant has testified to is in fact correct. Okay, that's one part. The other part I think you're getting at is sort of a general maintenance question.
Absolutely.
And we will comply. There will be a maintenance.
There'll be an O&M manual, operation maintenance manual for the on-site stormwater.
And-
Now, if there's issues
So
with
there's
the
accountability,
existing, if there's existing,
Well, there's.
Sorry, I'm sorry, Mr. Savage, I didn't mean to cut you off.
Legally, there'd be an O&M manual, right? So we're required to maintain our site. If there are other causes for an exacerbation of an existing condition on your property, that's obviously not the responsibility or in any way the fault of this applicant property owner.
Okay. I'm so sorry. Maybe he can apologize. Yeah. okay.
While there's a roll,
Let me also add,
making a left enter the building, we can't, it's illegal.
Oh, thank you very much, and that's written in stone. I hope your blood is on that contract and everybody else.
let me also add that there will be quarterly inspections of our facility that are required and mandated as a matter of law. This board, I'm sure, will condition its approval on our responsibility to comply with any and all laws that relate to the application and to the site. And so we'll have an affirmative obligation to do that. So there will be periodic inspections to ensure that our site will not be the cause of any off-site drainage problem with regard to your property. We cannot guarantee that another condition in the area would not exacerbate a drainage issue on your property, but
Convenient, yes, I agree with you, sure.
so,
It
but,
could be
but,
anything.
but understand that there
Yeah.
will be an ongoing maintenance and inspection duty for us under the law to ensure that our systems continue to work as intended.
And to clarify, when you say us, you
Yeah.
mean the owner, developer, operator,
Correct.
builder, et cetera. Can we shift over to sewage for a moment, please? Can you humor me again with that idea of an illustration of where does the sewage go? I don't understand. I know you filed them, and I apologize if I haven't reviewed every single document. So the sewage lines in the neighborhood, I have to assume, well, I know there's one that goes in front of my property. Where are all of the, where are you guys tying in, and where does
So-
that go?
our connection is on Afterglow, sort of as we're sort of approaching the intersection of Sunset.
Mhm.
That then flows towards the intersection of Sunset and
Going towards,
goes left,
to the left.
downhill.
Okay. This could be a question for the board as well. I'm sorry. God damn it, I'm so sorry. Okay. Do we know, or do you know, if that, you're telling me that that sewage line is fully capable of handling, what, 6 times more than it does now?
That was, testimony was regarding the lateral that we're proposing on site. I think
Okay, I'm
some
sorry.
of,
So like that line that goes down, is that sufficient for the current existing conditions and the addition of your project?
I mean, I think
Two-part
that-
question. Number one,
Well, one
is it
is-
sufficient now, and do you know that answer? 2, what's the impact from your development?
in terms of the first part, I mean, just based upon our discussion with township engineer, which we're discussing both the capacity of the plant and the actual capacity of the pipes. At that time, he told us that there was no known issue to the capacity of those pipes that are in the street. And second part, basically, we're going through that approval process with the township engineer. They're going to have to ultimately approve our TWA, the treatment works approval for sanitary sewer. We're in those discussions with them. We'll continue to meet with him, and if he recommends us to do some testing that was recommended here, then that'll be done.
In your opinion, is it standard practice to have a back valve installed in your house for sewage backup?
I can't answer.
Can I ask you another
If-
way? Why, I put on my lawyer hat for this one. Why are there so many houses at the bottom of the hill when you make the left that have a backup valve
Well,
for sewage? And
I understand, but first of all, we don't know that to be true. Second of all,
okay, I
that
have one in my house.
but that has nothing to do with the
Why do I
testimony.
have one in my house?
But I don't know, but that has
I'll answer
nothing,
the question.
but that has nothing to do with the
Because
testimony that was
sewage backs
provided.
up and ends up in our basements.
I'm
That's not a question or a debate, that's fact.
not disputing that.
So does that fall into your what is it, downriver? What's,
Did that fall in under the scope of a capacity analysis? No pun intended, I used the word scope, got it?
it's good, I like it.
Sorry.
I think we would have to defer on an answer to that question.
You won't answer, I'm sorry?
Well, we indicated, when the mayor was asking questions and making comments before, we had indicated that we would get back to you with regard to,
Well, we
Hey.
haven't determined whether anything will or will not occur on this yet. Yet to be continued, right?
yeah, I said we'd get back to you on whether or not the applicant would be willing to do a capacity analysis, and if so, what the scope of that would be. We're not prepared to commit to that this evening, but we've said we'd get back to you on it.
I'm happy with that answer that, like I said, it's just an open issue at this point in time.
Right.
You can
I got it.
come with a final response later.
The mayor or this board?
We're going to get back to the board.
Council?
I mean, I can call the mayor, but we'll get back to you, the board.
Well, I mean, the bottom line, I'm sure the council actually has the final say-so on most of this.
I will call Mr. Macera at precisely 4:30 in the afternoon.
Yeah, that's not going to work.
This application is currently before this board.
Yeah, we're not getting documents in time, we're not going to be able to discuss certain things. So, anyway, please continue.
Okay, so sewage is what it is. I assume it's no impact from your project. Is there an impact on the line down the river, down the road, that I should be concerned about?
I think that goes into what we were just discussing about here, that we're going to be getting back
Okay.
to them regarding the request from the engineer.
Okay,
We have to
apologize.
wait and see
Yeah.
where that's going to go.
Okay, I've heard a lot of back and forth about the model that you're using to calculate the stormwater runoff. Can our council or our engineer run those numbers?
I
as
already,
a point of reference. I'm
You're-
asking a question.
I understand your engineer can do whatever your engineer wants to do. Typically, I think the engineers review, they're reviewing engineers, they review the reports and the data that are provided by the applicant's engineer. And obviously, the board engineer has to be satisfied that those reports are accurate, but the laboring ore is done by the applicant's engineer. And if your engineer has questions or comments, then your engineer will address those. The bottom line is your engineer has to be, the board engineer has to be satisfied that the data and the reports are accurate in order to make an informed judgment
Certainly.
on the report.
If the township's engineer were to run numbers and they are completely incongruent with what you guys come up with, what is that, what's the process there? I mean, look, I'm asking a question and it's probably very ignorant, but I'm listening to what you're saying and it's concerning. And it seems like it's a fairly simple ignorance here again, I apologize. Why are we not comparing numbers? If there's an issue, okay, I'm going to stop. I'm going to stop there.
I think,
Yeah,
I think we're satisfied as a board that we have full confidence in
Yes.
Mr. Gonzalez. If there are numbers that need to be verified, the verification will take place, but we're satisfied that everything's good.
that was apology number 7.
Mr. Massaro, with due
I
respect,
do too, I
Dr.
apologize.
Gonzalez.
Okay, okay. And does the owner-operator bear any, do they assume any? I want to believe that this owner-operator is going to work with us. I know this isn't really a question, but it's coming from my heart, that he stated, yes, we're here for the long haul, right? If it wasn't me, it'd be some other developer here. I'm just asking for some empathy in general, okay? It's a pretty big disruption to our lives. It's going to be with building and construction. And maybe that's a question. How does construction affect the current state of stormwater management? Sewage, all right, sewage may not be the big deal, but when you guys are going through construction, how does that impact stormwater?
So again.
I know it's coming later in the process.
Well, no, as we discussed at the last meeting, assuming that there's an approval granted for this as-of-right application, there will be a developer's agreement, which will be entered into between the applicant and the municipality, and that developer's agreement will address construction issues. Those are not issues for the board.
Because that's a kind of a big deal. Would you agree?
Understood?
Yeah, okay. I just want to thank everybody for listening and taking the time, and thank you.
Madam Chair, if you want to recognize.
Sorry.
Name and address.
Hi, Luke Farrell, 43 Afterglow Avenue in Verona. Hi, thank you.
I'm sorry, your name again?
Luke.
Luke Fair.
Yeah, Farrell. Farrell, Farrell. Thanks for all the testimony. I'm just joining this process. I live up the street on Afterglow. So I had a few general comments and I'll ask you a couple questions. So
You really have to
I'm sorry.
keep your comments to questions.
Keep them to questions.
You-
Okay.
You have to make a question,
so,
you're asking specific questions to the engineer.
Understood. The way I heard this, a lot of, most of these are models and projections. Someone else alluded to ex post, measurements and how they might match up to the projections that we're talking about today. Is there precedent or are you willing to set up some kind of neighborhood insurance fund or escrow fund to remedy the
Mr. Farrell,
differences?
that's not a proper question for the engineer.
Okay, fine. So let me ask a very proper question on, you specifically mentioned as your sewer, instead of measurement, you suggested jetting a portion of the pipes, and you, right? Am I right? And investigating with a camera?
I was just referring to a suggestion from the township engineer.
Okay.
That was
You
the-
referenced a specific portion of Afterglow going up to Afterglow Way. Was that part of
That
it?
was based on the township engineer's recommendation.
Okay. that section is uphill. Do we agree that, can you explain why we might look at?
It's what the engineer wanted us to do. I think there was some concern that maybe that's where people had issues or something with, I don't know. That was at his direction. He specifically wanted those stretches.
Okay. That portion's uphill from the site, so if there was suggestions from the town engineer that might be an area of interest of, potential failure or impact from your property, would it not suggest that your property is adding significant volume and pressure to systems that it might cause uphill disturbance?
No, I think, and I can't speak for him, but I think his concern was that, I think at the one hearing where we met afterwards, there might have been some people on that street who might have been suggesting there was issues or something. So that's why he focused on that. In terms of the upstream, I think he was looking at if there's some issues in the road that is causing a backup in existing conditions upstream. But again, I can't speak for that's just what he wanted us to do.
The other question would be, is there a specific reason why the stormwater would be going towards Bloomfield Avenue, which is a much larger pipe, presumably a much larger part of the infrastructure, where the sewage is being diverted down the hill through the residential neighborhood rather than taking the same shorter route to a bigger?
It goes to the treatment plant, the sewer treatment plant. So drainage goes, to ultimately to a.
But there are other buildings on Bloomfield Avenue that also go to the sewage treatment plant. Is it feasible to tap into those?
The existing site does have a connection in Afterglow. I mean, that's where the building goes now. That's on that site, and that's the discussions we've had with the township engineer, and that's where.
Could it possibly be reconfigured to go out the more commercial route? I mean, you're talking about.
I'm not sure. We're talking
hill.
about pipes that are beneath the ground there. I don't know what the size of the pipes are out in Bloomfield.
Okay.
Yeah. So
Is that part of the scope to possibly look at? I mean, you're talking about putting 200 units on the top of a hill and diverting them rather, two different ways.
You're really not supposed to ask the board questions, but you raise a good point.
Okay, thank you. That's all.
Thank you. Anyone else from the public have questions for this particular expert?
Good evening. My name is Chris Riley. I live at 60 Sunset Avenue in Verona. You talk about the models and they work or they pass the test at certain levels. I think you said 1 in 10 and 1 in 100. Is that the 100-year storm?
We thought there's requirements from DEP for you have to analyze certain storm events. Yes.
Right. What was the maximum that you said that the model that you did passed? Was it 1 in 100, 1 in 1,000-year storm?
No, our design's on the 100-year storm event.
Okay. Was the storm from 2 years ago, Ida, was that a 100-year storm?
I don't know what it was, and I wouldn't know what it fell here.
Okay.
So.
Does your model do a breakage point? I mean, a lot of times when we do models in other lines of work, we would stress them to see at what point in time does this break. Do you know when that breakage point would be?
Yeah, I've never done that.
Okay.
I've never heard of that being done in this case.
All right. Thank you.
Thank you.
Nora Brennis, 47 Afterglow Way. Again, I'm a layperson and I have not seen all the models, but again, the unit with the sewage, it is going out to Afterglow Way, Afterglow Ave, only Ave, and Sunset, so it's only going down. It's not going out sideways?
I think you might be.
And maybe I am.
You might be missing. So the sanitary sewer is going towards Afterglow, and that's in the pipes. That goes down to the wastewater treatment plant, which that going down Sunset's the way to get there.
Okay.
The drainage, the storm drainage, storm sewer, that is the analysis that we have. Some of the site runs off towards Parkhurst, some of it runs off ultimately towards Bloomfield, some gets collected in our underground basins and then goes towards Sunset, and then some goes towards Afterglow and then ultimately down left on Sunset.
Okay.
So but that's the storm drainage.
Okay.
Yeah.
Thank you.
Hi, I'm new. I just moved in 3 months ago. Marta Leia, 10 after Glow. What? 10 after Glow. I'm sorry, your last name? Leja. To verify, the tests you'll be able to complete that are still TBD on the sewage will be able to tell us, will there be potential backups? I just want to make sure that there's not shit overflowing my kids' bedrooms because I'm literally the house across the street from you.
What the test would be, if we come to the agreement to do those tests, we would be showing that that system, the existing system, has the capacity, therefore, and that our contribution to it doesn't cause any issues. If there are some downstream issues that are existing that we're not impacting, that wouldn't be, fixed by what we're doing. But we just have to prove that what we're doing doesn't create an issue in that system. So that would be the result of that.
And this test that we're disputing right now is that one, right?
Well, there's not a dispute. We just have to get back to the board on what the applicant is willing to do in that regard.
But you agree you don't want my kids' bedrooms to fill up with shit, right?
I don't want any children's bedrooms to fill up with the substance that you eloquently have described.
Thank you. And you as a builder, developer, lawyer, for then we'll make sure, little things like that are precautions are taken, right?
That's not an appropriate question.
That's more of a comment.
It was a good question, but not appropriate.
If you can get him to say yes,
Right.
you can have a seat up here.
Okay,
She's smiling.
super quick question. I apologize, Jonathan McAvoy, 76 Sons of Ave. So rainfall, so what constitutes 1 year, 2 year, 5 year, 100-year storm? Is it volume of rain per hour? Is it?
It's inches of rain over a given period of time. So per DEP, we have to analyze the 210 and 100-year storm events.
So like an Ida, which is brought up, well, I'm just saying it was, I believe it was around 9 inches over a very short span of time. Do we know what that falls?
I have no idea what that, yeah.
Are there any other questions from the public? All right, we're going to take a 5-minute break.
Thank you. Not really.
I'm ready. Yeah, I'm ready. Oh, she's a fantastic. Please, thank you. Oh, at least I got that going for me. So, look, I had no new, there's nothing new in my exhibits. I'm just going to say, taking them in a nice, neat, clean presentation, taking through all of the changes and just so that it's all neatly formulated in their heads, and that's pretty much it. They have questions, I'll answer them, but I'm sure I've already answered them. The truth is, I almost want to say, neighbor-friendly development, company. They're really great neighborhoods for that. They have to be pictured as correct. It's yeah, but in fact, I think the ones that kind of sitting in the just even move it along. The one member. I've never had that before. Yeah.
Chairs about to make the applicants, so you know. Friends, neighbors, please.
No, maybe. Mr. Inglesino.
Thank you, Madam Chair, members of the board. Next witness is Mr. Jack Raker, the project architect. Mr. Raker, you understand you're still under oath, correct?
I do.
Are your credentials exactly the same as they were when you testified in connection with this application?
They are.
And you made some revisions to your architectural plans, have you not?
Yes, in assemblage, I've made revisions,
Will you
yes.
please share those with the board and the public?
Sure.
And
So-
you're not, and just for the, you're not offering any new exhibits? These are off of the sheets that have been submitted?
Correct. So all I'm going to do tonight, I resubmitted a new set of documents. I'm just going to go over that submission, the set of changes that were made. So there were sort of some updates, but essentially these are the documents assembled that I already presented to the board. There's no new information here tonight, but I want to make sure that the information here is clear to everyone on the board. So the first is the cover sheet. The only change to the cover sheet is the new list of drawings on the cover sheet that represent all of the new sheets, or essentially the sheets that were exhibited to the board but not part of the original submitted documents. So that's the only thing that's changed on this, that is C-01, the cover. On H-01, the only thing that was changed here, there was an update to the civil background at the entry. It's a new shape, so that was updated to be consistent with the civil engineer's drawings. Next is A02. This was an exhibit. It is now part of my submitted set. It's the balcony prohibition diagram. There's red lines showing where the balconies are prohibited. This is exhibit A-03. It's now in color. I've highlighted the low and moderate units. I did that when I did my presentation. It's now a part of a submitted set. I did add spot elevations around the building when I did my presentation. That is now part of the submitted set. We added a stair in the lobby, so that's shown. And the civil background was updated again to show the current layout. A-04. Again, the same things I did to the previous exhibit. I highlighted the low and moderate units, showed the spot elevation, added the stair that comes up from the lobby, and updated the civil background. A-05. Low and moderate units were highlighted. Again here, same thing, spot elevation, the stair, and the civil background. Let me keep going because essentially the changes are the same for all of the floor plans. A-06, same thing, low and moderate units were highlighted in green. Spot elevations were added, stair lobby that comes up from the lobby, and the civil background was updated. A-07, all of those items I previously mentioned, and the generator, oops, that's A-07, go to that sheet, and the generator location and dimensions were added, and that's A-07. You know, we did show them in testimony, but it was not part of the submitted set. A-08, again, the same as previous, the low and moderate units. At this level, this is where the 3-bedroom was increased from size, I believe was asked, we increased it from size 975 to 1175. We've located that unit and we've noted it on the drawings. This is A-09, and again, only the 3 original items were added. The low and moderate units were highlighted.
This three-bedroom unit was changed in size, the floor spot elevations were added, and civil background was updated. A10, the only thing changed here was the civil background was updated. A11, this sheet was added at the board's request and reviewed as an exhibit on 12/1. And then a section through the garage was added as well. That's section D, showing the light fixture heights.
Can you address that after you
Sure.
go through this?
I could address it right now if you'd like.
Would you please?
Sure. So we have, there we are, top. So the top section is section D. And at the very top of that, that section, you can see that the light fixture were added in their location. And there was a dimension shown. I could zoom in if you'd like. 1 second. Showing the height above the floor at 10.6. Now, the reason that varies is because the slope of the garage varies, and you can see the height remains 10.6, but the height above grade it varies. But it's always 10.6 above the floor. That's what is needed to disperse the light evenly throughout the top of the garage.
I mean, is there any way to disperse light without having such a tall light pole? I think this is just
There are alternates. I mean, and I don't think they're as nice. We could mount lights to the building, but then that would be shining the light from the building out toward the garage, and that would be toward the neighbors. I just don't think that's appropriate. It's easier to control the light on a pole where we can add shields. It's shining down. If there's any dispersion, we can shield it from those locations. It's just a much better solution.
Is 10 feet the going, like, overage that you need, the height that you need for?
I'm not really an expert in lighting, but what I can say is when I typically do these, I hear heights around 12 feet.
Okay, I'm sure
and
that
14.
they go beyond that,
So,
right?
but 10.6 is low of what I'm used to. I'm just, I'm not a light engineer. I don't really understand.
Once we figure out the height thing from ground, which was, I think, a question as to whether or not it exceeded the allowable height, depending on what you consider a light. I don't think that they've legally decided on that yet, but if, in fact, they have to be at that height in order to comply with certain regulations, I would like to condition, shielding to such a large degree that it absolutely will not spill out, or you won't see, the light will only go down.
I think Sean gave extensive testimony with regard to light.
And we will agree to shielding, and we will agree to work with the town engineer, the board engineer, even on a trial basis to get the shielding and to get the light exactly right. Again, as I said at the last meeting, we're trying to balance the need to provide light on the parking area for the safety of the people who were there against, any impact on the neighbors. We want to minimize, obviously, the impact on the neighbors. So, we would agree as a condition to work with your engineer to do that.
And this, of course, is only if we don't discover that the height of the lighting itself exceeds building height.
Well, I think the only way getting around that would be to give a design waiver. I mean, certainly the top floor of the parking deck needs lights. Otherwise, you're creating an unsafe condition.
I understand that.
So if the board were to decide that this is not or this is a structure and not mechanical, given the circumstances, I think this is where you issue a design waiver and you try to get the best possible result, rather than getting into the semantics of whether this is a structure or not a structure, because it's certainly going to have lights. So, that would be my recommendation.
Does anyone have any comment on that? Or any input on that? Sure.
I think the light head itself at right around 10.4 is relatively modest. I've seen 14 to 16 feet in certain instances. Certainly, as alluded to, putting in one of the requirements for as the approval is to do a 6-month evaluation where you can actually go out, measure the light, see what the ambient levels are, and if things need to be adjusted, they can be. So,
And shields.
yes, yes, absolutely. Provided that we still get those minimum lighting levels that are required.
We would agree with what he says.
Madam Chair, if I recall, the operator had given some assurances that they were willing to work with neighbors that come in and either talk to the manager and adapt during building. So as much as
Yeah, I think we'd have to work it through the town engineer.
Yeah, of course.
Because it has to be, but yes, absolutely. I mean, there would be this period afterwards, as was just recommended, we'd agree to that, and if residents want to speak with, the town engineer, and we get feedback, we can coordinate that. We want to get this right.
And I would say, there's going to be LED.
Yes.
Yeah, so you can play with the lumens as well as the color temperature, and so get the warm light, so it's not that, I would say from, that nasty old school acetylene is too orange, but these very bright LED lights would be equally distracting. So
We will do the best we can here, and we agree that there may be some tinkering
very good.
post facto to get it to the right balance.
So, Madam Chair, so considering we started off at 15 foot, this is, I would say, a job well done and acceptable. Is there possibility, do they ever put these on motion detectors?
I would have to defer to the engineer to do that, but my understanding is we're required in garages to maintain a certain level of lighting, whether people are there or not. So.
But I don't mean like all of them. Obviously, you don't want it pitch black. Some. No. Okay.
I think we have to comply to code. So I can't agree that a motion sensor will work if it goes against the code.
I think the only thing that you still have to maintain the minimum lighting levels. The only time that you might want to introduce some type of motion detection is if you needed additional lighting.
So supplemental.
Are the light fixtures themselves, the light heads, adjustable in brightness typically, or are they, when you buy them, that's how bright they are?
Again, I'm sorry, I'd have to defer. I'm not an expert in lighting. I'm pretty sure that they are. I mean, I've seen these light fixtures are, very versatile nowadays. Or
What you do, once you identify the type of fixture that you want, there's a color range that you go through. It has to do with what the gentleman alluded to before. So typically, if you're looking at something like 4,700 to 5,200 Kelvin, you would have a light spectrum within that to choose from, and then you can choose from that. But yes, you can dial them down as necessary. Typically, because of the LED drivers that you want to use, you're not going to have them on a normal dimmer. But there is things that you can certainly do to keep those levels like a constant.
I mean, color temperature and lumens produced are two separate factors. You can have a 4,000 K light source that's different dimming, and that's what I'm curious about. I know that like commercial LED drivers have like 0 to 10 dimming and ELD dimming and so on. I'm curious if outdoor lighting fixtures typically are adjustable.
Yeah, you put a multi-tap in there, and then you can tap as you need to.
Okay, good, thank you.
Thank you.
Sure. We're not moving forward. Yeah, it was just frozen for a second. I'm sorry, just get me through.
Okay.
A11, elevations. This is simply an exhibit that was presented at the previous time. The change that was requested by the board was adding articulation to the wall at the back of the garage that was previously presented. Elevations, this is where we added the garage grills at this location. And this, it's just been added and updated for the submission. This was the.
Point is the garage grills again, I'm just not seeing them.
Yeah, it's actually somewhat faded in the elevation because it's further back. This is the closest portion of this elevation, the next closest, and then the garage is further back. Because of that, we added the next sheet. So if you look at the next sheet, it's a blow up of that area with the garage grills shown.
Okay, I see those now.
And a sample photo of what those grills would look like. We presented this at the meeting already and testified to it. That was sheet A14. Sheet A15, again, this is a detail, A15, yes. This is typical unit plans and signage. There is no change to this sheet. A16, conceptual unit plans. These are the low and moderate units that were added to the set, and they were presented on 12/1. A17 was an additional exhibit that shows how we got from the smaller 3-bedroom and shifted the units down to enlarge the 3-bedroom low and moderate unit. That's A17. It was added to the set. A18 through A20 are the perspective renderings. Again, nothing's changed on these. They're all the same. They've just been added to the submitted set. So these are all the drawings that I've talked about, testified to in one organized document for the board. I'll take any questions that you have.
Anyone from the board have any questions for Mr. Raker?
No, I appreciate you going back and taking a look at the 3-bedroom units and making them larger.
Thank you.
Anyone else? Does anybody from the public, or do our engineers have any comments or questions for Mr. Raker? Okay.
Jonathan McElroy, 76 Sunset Avenue. Can you go to A14 for one moment, please? And this is just within the context of the lighting of the parking deck on the top level. Is that illustrated here? Because I'm not seeing...
It is not illustrated in this drawing. This is the drawing that was presented to the board. I showed the heights of the lighting in the section sheet.
Is there an approximation of where the top of those lights would be?
Typically, the lights appear over the piers in the elevation.
10 feet, is that... so the cap on there, you've got that light kind of concrete color at the top.
Right. So
what is the dimension of that height of that?
What you're looking at, I just let me describe what you're looking at. So what
Yeah.
you're seeing here is the elevation of the garage that's closest to you.
Yep.
That is the ramp going up, and that's the taller version of the garage. The difference in height between the two levels is approximately 5.5 feet.
So looking at the top, forgive my ignorance again, I can read a section in a plan, but the light portion going across the top of the parking garage.
Mr. Ricker, I think he's trying to ask,
Yeah.
let's say it's a parapet wall for the outside wall. How high is that wall off the parking deck?
It's approximately, we need crash protection, so it has to be about 42 inches high.
Okay.
We end up, because we don't want anybody to fall over, we have to make it that height.
So the light pole is going to extend approximately 6 feet over that.
Approximately 6 feet above.
The question is, where do the light poles?
What's your slab to slab height?
Slab is approximately the same as the building, which is 10 inches.
Oh, that's what I was asking about the building itself, so that we can try and figure out where on the building, just illustratively.
Well,
the top of those-
let me just, I'll sort of, because this is a blow up and it's not really to scale, I'm sort of give you an approximate. So the lights happen approximately over each of these piers, roughly.
So you're saying light pole here, here, here.
I believe so, yes. I'd have to look at the plan again to see the actual light locations, and I don't have that in front of me. That's the engineer's plan. But I did locate them in section when I drew the section. So if we're saying that this gray area in the back is about 5.5 feet, the light sits about 6.5 feet above this line. So the light on this side would be just above that gray area. Now, there are lights on top of that gray area as well, so they would sit about 6.5 feet above that, but that's, 120 feet back.
So you're counting basically the height of the light pole from this.
Correct, because the floor is below the edge of that line.
Yes?
It's more, we call it crash protection in the garage.
And then a little bit higher than that is.
About 6 feet is the top of the pole.
Are there any other members from the public that have any questions for Mr. Raker?
Robert Blitz, 12 Stillwood Parkway, Verona. I have one question for Mr. Raker, but I have a clarifying question first for the board.
Yeah,
Too
you're
close.
really too close, too close.
Oh, I thought it was too far away before. Sorry, I have a quick question to make sure I don't ask an inappropriate question. I know the questions are supposed to be for the witness, but the attorney gave testimony in a sense as well when you were talking to him. Am I allowed to ask a question that was entered into the record by the attorney?
You're allowed to
Bring
ask,
certain
the
things?
attorney represents Mr. Raker at this point, so the two of them are able to answer.
Okay, because I know I asked a question once and I was told to stop because I was asking the attorney.
You
Okay,
can't
first
ask
question. Okay, that's fine. First question for Mr. Raker. There was testimony probably 2 or 3 meetings ago about the level of light that would be visible by neighbors at a certain distance. I don't know if you recall that, if you were at that particular
I
testimony.
did hear the testimony, but again, I'm not a lighting expert, so.
Okay, I'll just ask my question. There was a certain numerical measurement entered into evidence at that time, what that lighting would be. Would you be willing to commit to either A, assuring that once the lighting is up, that those number of lumens would be at or below that level, or whatever that measurement was, or B, any town code that would be adopted for the lighting for a parking structure?
So, again, Mr. Raker is the architect. He's not a lighting expert, so he's not able to answer your question.
Okay.
Again, there'll be, I'm sure, a condition in the resolution which will require the applicant to comply with all applicable laws.
I understand that. Okay, fine. And then my second question was when we were discussing a few minutes ago, or you were discussing a few minutes ago, about the lighting, not to make too big of a deal of it, but the attorney mentioned that he'd be willing to work with the town engineer and others on the lighting, and the exact wording that was used was, as I wrote down, was they agree that there may be some changes. So agree that there may be. May is not a definitive commitment. It's a conditional.
Mr. Blitz, we can take care of that in the resolution, the conditions in the resolution. We'll make sure that the language is not vague and there is somewhat of a requirement on the developer to tinker, as was the word that was used, but we have faith in our engineers that will make it right. We have to be as little intrusive as possible to the neighbors while maintaining compliance with all the lighting regulations.
And I appreciate that. As you know, in Other agreements, there was a lot of vague wording that the town adopted. Thank you.
Thank you. Anyone else?
Hi, Luke Farrell, 43 Absago Avenue. Nothing about the stationary lighting that we've been talking about, but I don't know the exact structure of the garage, but cars that are driving in with their headlights on at night, it looked to me, is there some kind of a turnaround or ramps where you have to turn?
Yeah.
Not specific to the roof, but probably likely on the roof, but potentially in the open air, multiple areas. Will any of those lights, or has any study been done on how, headlights will be shining at such a high elevation? I think it said it was about 60 feet above the ground at the top level. As cars enter at night, will they be shining into people's windows and houses in the neighborhood?
We discussed that at the previous meeting. We do have, again, we have a crash protection that's 42
So a lot of that
inches.
is hidden
That's all, our headlights are below that level.
Okay.
I mean, you have to have a really high truck to get above it, and then you wouldn't fit in the garage, so.
Okay. Yeah, sorry if it was addressed.
Yeah, no problem, it's a good question.
Chris Riley, 60 Sunset Avenue, Verona. My question is, if the settlement agreement was for a certain height, why didn't you design the garage to meet the height requirements with the pole in mind?
I can answer that the pole is, the light fixture is not addressed in the ordinance at all. Flagpoles are exempt. So if we wanted to make these flagpoles, they would be
I'm not
exempt.
talking about flagpoles, I'm talking about the lights on the top of the
Yeah.
garage.
Yeah, they're, as far as I'm concerned, they're part of mechanical equipment and they are exempt. That was my interpretation.
Okay. Did you know that there was when the settlement agreement was being negotiated, did you know that there was a 4-story garage being planned at the time?
I don't understand what was going on during the settlement agreement, but when I received the ordinance, I designed this project.
Okay, so you
Yeah.
you designed the project after you received the settlement agreement?
After I received the redevelopment ordinance.
Okay.
In other words, Mr. Ryan, just to help you out, so there's a settlement agreement that agrees in broad terms to what the project is going to be. There aren't there aren't bulk requirements like height and so forth and so on. After the settlement agreement, the town then went through a redevelopment process and adopted a redevelopment plan, which basically is the ordinance, is the redevelopment plan. So when you're saying settlement agreement, I think you mean...
I might be using the wrong term.
Yeah, redevelopment plan, and I think what the architect's testimony is that he designed the architecture in accordance with the redevelopment plan.
Right, and I remember participating in town council meetings where they talked about the height of the building. I mean, I guess, why have that in the agreement if we're not following it?
My understanding is this
Why didn't you design like a 3-story garage instead of a 4-story garage?
Because, I can answer that, because the project is the project. The project the project is 200 units, and so you have to be able to park it. So if
Listen, I'm going to interrupt it. Obviously, there was some sense of a miscalculation on their behalf in terms of calculating for the light poles. This has been discussed umpteen times throughout our different meetings. We're not happy about it, but there's a law that surrounds ample lighting in a parking area, especially on the top of a dark parking deck. So they're saying that they're going to work with the neighborhoods, the neighbors, and anyone who seems to have an issue. And yeah, it sounds like there was a question surrounding the height of the light pole versus the height of the building. And I don't believe that it's legally even been determined that they aren't beyond it. But as you heard Mr. Massara tonight talk about a general granting of a waiver for the 10 and a half or so foot light poles. And I just, unfortunately, I think that's where we're at. I agree with you that it was somehow in error that they didn't think of that, but I think that's where we are now. I mean, you're welcome to ask another question about it, but I think,
No, I guess I understand their position, and it's more of just, why is the council doing that, which I guess I save to another time. Thank you.
thank you.
I mean, height is measured to the roof, and that's what we're doing. I really
Yeah,
honestly,
know.
I don't, as an
don't know.
architect,
think There was a legal discussion.
Yeah, I mean, they can,
that
I
they've
can only
had.
give what my opinion is, and I've been before hundreds of boards in the state of New Jersey, and never has it been measured to the top of a light pole, ever. This would be the first time
I don't
in
think
history.
that, it wasn't measured to the top of a light pole. It was a question of whether the light pole is a structure, and the ordinance allows excess height for certain exceptions.
Mhm.
And light poles were not a certain exception. So the question arose whether light poles were allowed because the ordinance was silent, or whether it should have been specific, light poles should have been explicit exceptions. But I think, I expressed my opinion before as to the resolution, is that if in fact the ordinance does not allow them, then the board would be inclined, the board would have the option to issue a design waiver. Mr. Inglesino has not agreed with my position that a design waiver would be necessary, but that resolves the issue. So if that's the board's inclination, then the board could go with that, or the board could decide that, as is your position, it's not calculated into the height. So.
Well, Mr. Raker, we're on that. Let me ask you a couple of questions. So you've designed roughly how many multifamily development projects similar to this particular project?
Maybe 150 to 200 projects.
And in how many different municipalities?
I would say probably roughly 120 something.
In New Jersey?
In New Jersey, yes.
And have many of those projects had light poles on top of the garage?
I would probably say those with a separate parking structure would be in the neighborhood of 20% of those, 20 to 30% of those projects.
So that would be 40 or 50
Roughly.
different projects. And your testimony is that in all of those municipalities, none of them have determined that a light pole constituted a structure that would require a variance.
That is correct.
Okay, thank you.
Mr. Raker, how many designs have you finished based on Verona's redevelopment plan?
Just one.
Thank you.
Well, I think the answer was obvious.
Are there any other questions from anyone in the public for Mr. Raker?
I should have said all of them.
All of them? All one?
Farrell again, 43 Afterglow. Maybe this is Frank, but why do other projects in other municipalities matter to one that's being discussed in our municipality?
I don't know, other than in the legal terms, it may set a precedent.
Wouldn't there be a lot more studies and classifications needed based on density,
Well,
neighborhood tax? There's such a generalization to make that other municipalities matter
Yeah,
without going into significantly more detail.
He wasn't saying that. I asked the question. He didn't offer that. I asked
Okay,
the
so
question.
why is that relevant?
Mr. Farrell, I think we're not really asking, we appreciate your questions, but we're not really asking the architect questions about his plan. We're getting esoteric, and not just you, all of us. So, right.
And when we're talking about an exception to a 4-story building limit that's now actually 5 stories.
Right, but that-
It is relevant.
But your question is not related to that, so.
No, it's just.
We understand.
Yeah.
Right. Thank you.
One thing I could offer up is the adjacent building to the garage is taller. Taller, same height, but taller as it sits up on the hill.
But from ground elevation, it doesn't exceed.
It does not exceed the allowable height, no.
Right. Does anybody else actually have a question for Mr. Raker? Like, let's stop asking Mr. Inglesino questions, because we could be here till 3 in the morning. Seeing none, does anyone else from the board have any questions for Mr. Raker? Okay. You carry this meeting. Do you have anything else to share with us tonight?
Not for this evening.
What do we expect for April 27th?
As we sit here today, we expect Linda Teicher, our landscape architect, she will be coming in from out of state. She will be flying in for the purpose of providing her testimony. So we would anticipate that testimony on April 27th.
May I ask if she is going to be submitting any sort of alternate or revised plans based on the redesign of the site that was submitted on January 11th by, yes?
I'm advised that the answer to that is yes.
Good.
And
when are we going to get those?
I don't know, but they would be within 10 days prior to the hearing, or 10 days, at least 10 days prior to the hearing.
The only thing I may add here is that specifically because this witness is flying in for out of state, I don't think that any of us would want to inconvenience her or cause the applicant additional expense by making her come back. So I'd really like to make sure we're able to review all those plans in detail with sufficient time and get through all of our testimony. And
Point well is registered, Mr. Mayor, and Mr. Thomas will convey that, I'm sure.
And yes, in addition to that, you know, we're going to be receiving a revised set of plans. They were extensive plans because it's obviously a lot of stuff going on that site. The Environmental Commission, just to be clear, had made some requests of the landscaping to diversify their trees away from deer food. You know, one type of evergreen tree and only one type, and it's an American arborvitae. And it's just basically going to be gone in a month.
We recall the letter. That was the letter from August, I think, right? From
That was yes, we sent that letter.
Yeah, no, she has that letter.
Bottom line, if we could get her plans sooner, the sooner the better, because that gives everybody time to actually maybe send some kind of something back to her before she flies up here.
Understood.
I'm just trying to make it better for her.
We appreciate that. We'll convey the message.
Okay. So just her next meeting, is that your plan?
If we have time at the next meeting, we would call Mr. Savage. You wanted to hear testimony. You requested testimony from Mr. Savage relative to the updated stormwater management report based upon the standard.
Mr. Savage actually said that he didn't know that he would be done and have us have ample time, or our engineers have ample time to
Okay,
review.
if it's submitted and if he can, that's the only other possible. I don't think there's anything else open for witnesses other than Mr. Savage after Ms. Tyson.
Just bring the flowers, right? Okay.
So it's probably just Ms. Teicher on the 27th. But if that changes, we'll let you know.
Mr. Inglesino, since you are wrapped for this evening, do you consent that this application can be carried?
We do.
And for members of the public, this application will be carried until April 25th, April 27th, 2023. At this location at 7:30 p.m. There will be no further notice provided to the public.
Motion to adjourn.
Motion to adjourn.
Oh, we have a motion from Mr. Katzap and a second by the mayor. All members, aye.
Oh.